Okay, hello everybody. Thank you for joining us in the latest in our series of construction and engineering law webinars. My name's Patrick Cooney. I'm a partner in the construction team, and we'll be introducing you to our speakers shortly and chairing the 15-minute session for questions at the end. Not going to give you the hard sell about Burkitt's today, but there's a few stats there about the firm. We're a full-service top 50 law firm with offices across the UK, 7 different offices across East Anglia, London, Bristol, and Sevenoaks. On the next slide there, I've brought up our speakers. Chris is going to be talking to us about the JCT's new Target Cost Contract. Then Sara and Naomi from our procurement team are going to give an update on procurement law developments. And Milana is going to round us off with a case law update. This session will last around 45 minutes in terms of presentations, and the idea is to leave around 15 minutes at the end for questions. So please do feel free to chip in with questions using the Q&A tab, which you'll see on the top ribbon at the top of your screen. Okay, so without further ado, I will hand over to Chris, who's going to talk to us about the JCT's new Target Cost Contract.
Thank you, Patrick. Good afternoon, everyone. So we're going to be talking about the new JCT Target Cost Contract as part of its 2024 suite. But firstly, I thought I would say some words about what actually is a Target Cost Contract. So target cost contracts are a form of cost reimbursable contract with the starting point that the contractor is paid on an actual cost plus fee basis. So no fixed cost for the works is agreed up front, and instead the parties agree an estimate of what they believe the works will cost. This being what is known as the target cost. And this target cost should reflect a genuine and properly substantiated estimate of the likely cost of the works and should be developed between the parties on an open book basis. Getting that target cost, therefore, as accurate and realistic as possible is critically important, as it will serve as the base against which the success of the project from a cost perspective is judged. The upfront target cost is typically adjusted during the construction of the works to account for things like variations and delay events, much like a fixed contract would be adjusted under other forms of contract. So this ensures that the target cost accurately reflects the anticipated cost of the works throughout the construction phase, but also that the contractor is not unduly penalised due to events beyond its control, where it's required to incur more cost. So the actual cost, therefore, just means the costs incurred by the contractor in carrying out and completing the works on a pound-for-pound basis, and a pre-agreed fee, which essentially covers the contractor's profit and overhead costs with any sort of risk allowance. There can be pre-agreed disallowed costs where the parties agree up front what that might be and which will not be payable to the contractor. And everything is valued on an open book accounting basis, so the contractor's accounts and records are regularly reviewed and assessed during the construction phase and up to the final account stage to ensure that any actual cost applied has been properly incurred. And for a target cost contract, there are also pay and gain share mechanisms. So following completion of the works, the final cost for completing everything is assessed against the target cost to determine whether the final cost is lower or higher than the target cost. And any pay and gain then is shared between the parties in pre-agreed proportions. So those of you who know that the JCT have not really had a target cost contract for some years and very usually use fixed cost contracts. So why have they gone for a TCC or target cost contract this time? So these are the objectives of JCT, which they sort of set out in trying to promote a target cost contract. Firstly, they see it as encouraging collaboration by encouraging open book accounting and promoted cooperative working practices, improve cost transparency with that open book approach to valuations, which means that the contractor must provide detailed records of the actual costs incurred and also allows the employer to have inspection rights to verify these costs. But I guess also it shares the risk and reward, and JCT in their introductions and when they launched this, talked about the current financial market with contractors and maybe sharing of risk and reward might help the industry. So this moves away from traditional lump sum contracts where the contractor bears most risks and distributes that financial risk and reward between both the employer and the contractor. So putting these together, collaboration, greater cost transparency and sharing of risk should lead to an improved project delivery. And I guess as an observer, I think I'd also say that JCT is a commercial organisation, so putting out this form does offer an alternative to an NEC target cost options, making JCT forms perhaps more competitive, particularly maybe for public sector projects. So because we've got a short session here, I'm not going to go through all of the JCT TCC contract. However, for those of you who are used to JCT forms, you should be aware that this is completely based on a JCT design and build form. Therefore, the risk profile is exactly the same. The only difference being with a target cost is that clause 4 of JCT has some substantial changes. So what I thought I'd do is just go through some key payment mechanisms of the new contract. So the target cost, which is this agreed baseline, sets out the proposed target cost for the project. But how is this calculated? So the employer's requirements should set out in detail the parameters with which the contractor should base target costs, including the format and also the level of detail that is required for what's called a target cost analysis, which is prepared by the contractor. So JCT in its guidance recommends that this target cost analysis should be as detailed as possible, and the employment's requirements are as prescriptive as possible as to the format and the level of detail that the employer requires. So this target cost can be adjusted in a similar way to the contract sum for other JCT contracts. Schedule 1 sets out those circumstances, and that includes the standard changes, acceleration quotations, fluctuations, loss and expense, and costs of contractor suspension. Moving on then, the second key payment mechanism I just wanted to pick up on is the allowable cost. Now, the allowable cost is calculated in accordance with Schedule 2, and this is quite an involved schedule, 4 or 5 pages, which has 7 parts. Part 1 is general provisions, which includes lump sums which can be used in lieu of actual costs. Part 2 is subcontract work, so that's costs which are due and payable under the subcontracts of the contractor, but not costs which are due to a contractor default. The contractor's management and design staff on site, so the contractor is expected to provide a list of directly employed management and design staff, including their relevant terms and conditions of employment, as payments of salaries and items such as bonuses and contributions to pension schemes even will be considered as allowable costs. So you can see that this will require substantial disclosure by the contractor of information which perhaps they've not been used to previously. Part 4 is the contractor's direct workforce, so this is other staff other than management and design staff, based on numbers and trades so that they're not identified individually. However, you will need to identify the relevant terms and conditions of employment. Parts 5 and 6 relate to materials, goods, plant, service and consumables, and Part 7 to sundry costs incurred by the contractor. So as I said before, the contractor is to keep all the records for inspection to which the employer should be granted access. But if the parties want to include a category of cost in addition to what's set out in Schedule 2, this can be done by specifying what that allowable cost is within the required entry in the contract particulars. Schedule 2 also sets out exclusions to the calculation of allowable costs, including costs that are not properly substantiated by the contractor's records, costs of making good, breaching subcontract requirements, and any trade discounts that are received by the contractor. So the third key payment mechanism is the contract fee, which is intended to, as I said before, represent the overhead and profit element that is not captured in the allowable cost element. Now, JCT provides 2 options, either a percentage fee or a fixed sum. And where the contract fee is fixed, it can be adjusted to take into account the difference between the original target cost and the final adjusted target cost based on a pre-agreed percentage-based threshold, which is calculated in accordance with a formula which is specifically set out in Schedule 3. If the parties don't agree this percentage threshold, then the default position is 0%, which means that the contract fee is adjusted based on the same proportion as the target cost adjustment. So agreeing the contract fee, therefore, will be a key commercial issue in any contract negotiation, as it's intended to cover all costs and expenses not covered by the allowable cost. So the final key payment mechanism then is the difference share or pay and gain share. So this essentially sets out what happens where there's any savings or overspend and they are shared between the parties. And the idea is for the parties to collaborate to avoid overspend and increase savings and therefore hopefully obtain a gain. But as with all commercial agreements, the share should be agreed in advance, how they'll be allocated and when this calculation takes place. Again, this can either be a fixed sum or a percentage of the pay and gain. Now, the contract particulars also describe the use of bands that are based on percentages or fixed monetary amounts. And if you were to use bands, you'll also need to agree the employers' and contractors' respective percentages that are applied in any band. So it's not possible, or is possible, to agree different percentages for each band. And TCC has a default that as where no percentages are stated, then it's a sort of 50-50 straight split. Now, the difference share can also be calculated at the end of the contract, but also during the contract after each interim monthly payment. And to do this, you just need to choose to apply clause 4.71 in the contract particulars, but this will apply as a default if you haven't done so. So I thought I'd just then spend a moment on what are the benefits and challenges perhaps of using a TCC contract. So the obvious benefits are that TCC encourages collaboration between employers and contractors by aligning their commercial interests through a target cost mechanism, and this should incentivize both parties to work together to improve project delivery. The pay and gain share mechanism aligns employer and contractor interests and promotes teamwork and cost efficiency. It does require a robust open book accounting process, but this provides greater visibility of actual cost, which promotes transparency and therefore should reduce disputes and improving trust between the parties. It also allows flexibility in calculating this difference share in the pay and gain mechanism, which can be applied either monthly or upon the project completion, depending on how the parties want to agree it. However, it does come with challenges, and clearly with the higher transparency and auditing, there's a higher administrative overhead, lots of detailed cost records and verification processes, as well as the need to manage adjustments to the target cost and allowable cost. I think it's important also that the target cost must be realistic. If you set too low a target cost, and this may be due to commercial pressures, this could lead to an immediate pain sharing and might undermine the collaborative intent of the contract. Also, potential disputes over what counts as allowable costs could also be a challenge. If it's not included in Schedule 2, then it's not allowable. But the lack of a concept may be equivalent to disallowed costs in NEC, may lead to disputes over the recoverability of certain costs under TCC, particularly regarding defects and delays and discounts. So maybe you'd want to consider including a list of disallowed costs in your contract. So I think, therefore, just wrapping up in summary, I think JCT TTC is a modern collaborative contract, and it's ideal for projects where cost certainty is difficult, but the parties want cost control incentives. And clearly, it encourages shared responsibility and transparency in the construction process. That's the end of my session. Thank you. I'm going to now pass you on to Sara and Naomi, who are going to take you through some procurement reform.
Thank you, Chris. I'm Sara Sayer. I'm the partner who heads the Administrative and Public Law Disputes team, and our contentious procurement practice falls within that remit. So I just want to take a moment to do some scene setting. The value of procurement within the UK. The latest Cabinet Office data shows that external procurement in the public sector accounts for roughly 300 billion of spending across all levels of government each year. I tried to drill down to see what the construction spend is, and the latest data that I could get my hands on is the 2023 ONS construction stats that suggest that construction work amounts to about 139 billion. And by that, we mean infrastructure work, housing, and other public works contracts. So it's a significant amount of UK public sector procurement spend. Procurement has definitely gone up the government agenda. And if we just remind ourselves as to why we have the procurement regime, the NAO put out a report in July 25 that said effective procurement processes help government secure better VFM by reducing costs, improving quality, and fostering innovation. But enough of the policy. I'm going to hand over to Naomi now, who's going to skillfully take us through recent key developments and practical insights.
Thanks, Sarah. So I'm Naomi Westcott, and I'm a legal director in the Admin and Public Law Disputes team. And I regularly advise both contracting authorities and bidders in respect of procurement disputes. So I thought for this first slide, it would be helpful for those of you in the construction industry just to have an idea of whether or not your contract value is within threshold and therefore whether the procurement rules apply. These figures are up to date, but they may be renewed or updated on the 1st of January 2026, and they are all inclusive of VAT. So the Procurement Act 2023 is a big change, and it came into effect in February 2025, and it replaces the Public Contract Regulations 2015, the PCR, following the UK's departure from the EU, and it reforms the UK's system of procurement. So we're just looking here at the slide at some of the key changes. Under the old regime, we had the most economically advantageous tender. And what that was a focus on price and cost effectiveness as the dominant factors, with quality and social value considered, but often secondary to lowest cost. Under the new regime, we just have the most advantageous tender, which is a broader concept about the best overall outcome. So it's not just economic, and it allows greater weight on quality, innovation, sustainability, and social value. So price is still relevant, of course, but it's not the sole driver, and it's important for those of you bidding on contracts to understand that. Section 12 are the new objectives, and these are largely the same as what we had under the PCR, save for the new ones are public benefit and reducing barriers for SMEs. Now, what is new is the debarment list, and that's a central list that's going to be made in relation to people who are going to be potentially excluded, and it's yet to be seen how this will play out in practice. For example, those suppliers on the Grenfell Tower tragedy are not yet on any list because that process has been paused pending the criminal investigations. And there are also increased transparency obligations for contracting authorities. One of the key aims of the Act was to create a fully transparent public procurement system such that everyone could understand what the UK public sector wants to buy, how much it's spending, and with whom. So, practical insights for you. What are the common grounds for challenging procurement decisions? You've worked very hard, you put in your tender submission, and then you receive your outcome. And hopefully it's successful, but it may not be. And in those circumstances, you have a decision to make about whether to challenge. It's important to note that we haven't actually seen that many challenges under the new Act, and that's because of the number of frameworks still being used for which the PCR regime continues to apply. And case law is still awaited under the Procurement Act, with only a handful of cases issued at High Court and no judgments yet. But we anticipate it will continue to be evaluation errors that are one of the predominant reasons for challenge. And with evaluation, the courts expect the authorities to follow the disclosed criteria and scoring methodology. Misapplication of scoring, undisclosed criteria, and benchmarking are examples of where an evaluation error may be challenged. And we've recently acted on behalf of a contracting authority where there was a challenge in respect of benchmarking. And what that is where the evaluators see an idea in another bid and then mark another bidder against that idea. And that is not permitted because that is not in the award criteria. So a tip for bidders is to scrutinise your evaluation feedback very carefully to ensure that there aren't any inconsistencies. And tip for contracting authorities is you need to make sure that you're marking against the criteria. And we can help with both of those. But if there is an evaluation error, is the court going to find that that's a breach? Well, that question comes down under the old regime was manifest error. And that was an obvious mistake. But that's always been another way of saying irrationality. And that's the new test under the Procurement Act. And that's a public law duty. So irrationality is a decision that is so unreasonable that no reasonable person could have made it. And it's a high threshold. Courts will not substitute their judgment for evaluators unless there is a manifest error or irrationality. So other potential areas of challenge are transparency failures and equal treatment issues. Equal treatment is still a core principle under the Procurement Act, and unequal applications of or preferential treatment is unlawful, and often that overlaps with the evaluation errors that we've just gone through. But an area that we may see a real expansion of challenges is debarment because of the new debarment list. Exclusion was always an area of challenge, and we recently acted on behalf of an unsuccessful bidder on a construction contract, where they said that the preferred bidder shouldn't have progressed past the selection stage because they failed to meet the financial standings requirement. So what that shows is that the challenge to selection isn't always necessarily from the person being not progressing, but also against you not excluding a certain other bidder. So a key message from us is when you come to challenging a procurement decision, time is absolutely key. Time is ticking from the moment that you understand the award that's been made. So under the PCR, there is a 10-day standstill period between the standstill letter and contract signing. And under the new Procurement Act, that's now an 8 working day standstill period starting from the contract award publication. One key change that we think is going to happen, albeit case law awaited, is that under the new Procurement Act, you will not get an automatic suspension if you do not issue your claim within the initial standstill period. And automatic suspension is something I'm just about to come on to. But it's also really important to note that there's another limitation period running. There's a 30-day limitation time period running in the background. And you really need to make sure you don't miss that because it would debar you from bringing a challenge. And so what that relates to is that there's 30 days to bring a claim from when you knew or ought to have known of the grounds of challenge. So it means that if you have a complaint, for example, about how the procurement's been set up, if you complain about that at the end, then you're out of time. So the automatic suspension, this is a really powerful remedy that the claimant or unsuccessful bidder has open to them. And it has a really disruptive impact on the contracting authority because it prevents them from being allowed to award the contract to their preferred bidder. So what does that mean in practice? Well, if you've got a good claim and the contracting authority knows that, then they're likely to be prepared to rewind, remark or rerun the procurement. But if they're confident in their position, then you can expect them to swiftly make an application to court to have the automatic suspension lifted. And the automatic suspension under the current regime is very much, the PCR, is very much weighted in favour of the contracting authority seeking to lift it. And under the new Procurement Act, leading practitioners in this area anticipate that it's not going to change much because whilst the test has been changed slightly, it remains very much weighted against the unsuccessful bidder and in favour of the contracting authority. By way of example, and these are all under the PCR, but in 2025, there have been 5 applications to lift the automatic suspension heard by the High Court, and of those 5, 4 have seen the awarding authority succeed, with only 1 application successfully resisted by a claimant. And what does it mean for a claimant if the automatic suspension is lifted? Well, it means that you're left with only a damages claim. You're not going to be awarded the contract. So just finally from me, some tips for bidders and the contracting authorities. For bidders, my tip is early engagement. Clarify ambiguities during the tender stage so that you don't get caught out by the 30-day limitation period. You can't complain later. So use the clarification questions available to you and check carefully against the published Q&A to ensure that your submission aligns with what the authority wants. And for contracting authorities, my advice is to have robust audit trails for evaluation and document decisions. Why? Because if you do, the court will allow a wide margin of discretion to contracting authorities in evaluation, and it will be very difficult for a claimant to prove that there's been a manifest error or irrationality. Thank you. I'm going to pass back to Sarah now.
Thank you, Naomi. So I've been practicing for 25 years and I've been doing procurement disputes for 15 of those years. And sometimes you really do need to see it to believe it. So in my time on cases we've dealt with, clients have so far complained of brown envelopes of cash going to contracting authorities. I've seen a car bought for a marker, a formula that was wrong in the bid process. So all the maths for all bidders was all wrong. We've seen maths and scoring errors aplenty. And we've also had one of the bidders had a relative who was the moderator at the contracting authority. And this has been on some household name procurements. So, you know, things do go wrong and we do see them. So as Naomi said, a tip from us is to speak to us early. Now, one of the most common things we hear from clients is you're very aggrieved, something's gone wrong, you've probably got evidence of it having gone wrong, but actually you don't want to rock the boat. It's a small industry, and actually if you challenge, you might never work in that industry again. What I would say is we've been doing this a long time and we have ways and means and things we say and things we do that recognise that. We totally get it. Ultimately, you want to get this work and you want to work with that contracting authority. So it's a very sensitive, delicate balance, and you want to keep that relationship alive. And we factor that into our approach to such procurement disputes and challenges. Now I'd like to hand over to Milana for the case law update.
Thanks very much, Naomi and Sarah. My name is Milana Masterson and I'm an associate here at Burkitt's and I sit in the construction team. And as Patrick said right at the start, I'll be providing the case law update. So 3 recent cases in the TCC. In view of time, I won't go through them in comprehensive detail, but please do send some questions through. So the first case is Malice and Persimmon Homes. The judgment only came down in October 2025, so it is fairly recent. And the facts are relatively simple. So the claimant, Mr. Malice, bought a family home from the defendant, who was a developer, Persimmon Homes. And quickly after they purchased the home, Mr. Malice became concerned about the amount of cracking in the plaster at the property. It was actually common ground between the parties that this cracking was caused by Persimmon Homes, so caused by the structural movement, by Persimmon Homes digging the trench strip foundations too shallow for the ground conditions, which was on London clay. And the evidence actually showed that this was exacerbated by the removal of a tree on the property as well. So Malice commenced proceedings on these grounds on two bases. One was on breach of contract, and the second was under the DPA. Persimmon Homes in this case actually admitted to these breaches, so the court didn't have to consider whether there was a breach or issues of causation. The key question that the court was considered in this case was what was the appropriate remedy to award. So Mr. Malice, the purchaser of the home, contended for complete demolition and rebuild of the property. He said, no, the whole thing's got to be gone and rebuilt. As you might expect, Persimmon Homes didn't agree, and they said, no, it's essentially just a repair job is all that's needed. A complete rebuild would be disproportionate and too excessive. Now, the court actually agreed with Persimmon Homes, and it really underlines that the key consideration that the TCC will look at in assessing remedies is proportionality. In these circumstances, they said the complete demolition and rebuild that Malice was vying for would be disproportionate and unreasonable. And the court placed a lot of weight on the evidence in that case that the property was actually generally fit for habitation, except for areas at the porch, as they endorsed what they called the robust and technically appropriate approach, which was underpinning the property. And this was all stemmed on evidence in that case. And this really also underlines the importance of evidence. So the court is not going to engage in speculation about the extent of evidence. They're really reliant on the evidence before them. So this becomes very, very important. In this case, it never fell for the court to actually consider or analyse the DPA claims versus the contractual claims. But just something to note is in the 2022 amendments to the Building Safety Act, it has actually extended the limitation period for DPA claims to 30 years. It wasn't an issue in this case, but just to say, if you are running into limitation issues in terms of contractual or tortious claims, it is well worth a look at to see if you have any claims under the DPA, because it does have this the benefit of the 30-year limitation period, which is quite a useful route. The second case that I will go through is VMA and POL. This essentially was an application for a summary judgment of an adjudicator's decision, and the ultimate question for the TCC was whether the decision could be enforced. The facts again are relatively simple. So VMA submits a payment application alleging that they're owed £106,000 odd, as you can see on the screen there. And the crucial point, and this is really important, is that VOL does not submit a pay less notice in respect of that payment application. However, the POL then commences a TVA, a true value adjudication. It says, well, what is the gross value of that £106,000 sum? This is where it gets a little bit complicated. So the adjudicator ultimately decides that VMA is successful. And the reason for this is that the operation of this act, so as you can see on the screen, I've stepped out the relevant provisions. There's quite a lot in there, and there are competing payment obligations in there. But the reason that VMA was successful was this notified sum. So the fact that they had submitted a payment application and POL had not submitted a pay less notice meant that that £106,000 odd pound figure generated or constituted a notified sum, which was an immediate payment obligation, which POL was obliged to pay. And this constituted a full defence to that true value adjudication. So VMA, being successful, then applies for enforcement in the court. And as you might imagine, POL tries to oppose this on the basis of jurisdiction and saying, well, we don't agree with what the adjudicator has done. And the ultimate question for the court was effectively, well, one of them was effectively the same as was posed to the adjudicator, as you can see in that final pane of that slide there. So essentially, how does the act operate? And it gave a really, really helpful insight into the architecture of those payment provisions. So essentially the upshot is that the TCC agreed with the adjudicator. It's stepped out a little bit clearly here. They termed this the principle of subjugation. So essentially the Act has competing payment obligations. Here, as you can see, the contractor has issues the payment application for the sum that they say is due to them. So that's the notified sum. So in this case, it was £106,000. If the employer then doesn't issue a pay less notice in the time that's required, the contractor then has a right to a smash and grab adjudication for this notified sum, and this constitutes an immediate payment obligation. So the employer almost by default needs to pay that. The employer also obviously has a right to a true value adjudication under the Act, but this right, when there's that competing interest, is subjugated to the immediate payment obligation. And you can see the quote at paragraphs 27 of the TCC that the court is saying, well, if you already decided that VMA is owed that sum, it'd be an arid exercise to require them to commence another adjudication to be awarded that sum. So the court decided that that £106 figure was a full defence, and in those circumstances, they agreed with the adjudicator. The third and final case that I will go through is Clegg Food Products Limited and Prestige Car Direct. So the facts in this case are a little bit more confusing. So firstly, just by way of background, Prestige Car Direct engages Clegg Food Products, who's the contractor, to design and build a leisure centre in Bishop Auckland. After practical completion, Clegg, who's the claimant, issues a payment application. In these circumstances, the defendant does actually issue a PLN. So we don't have any of those same issues as in VMA and POL in respect of the principle of subjugation or any of those things. However, a dispute does arise in relation to the gross valuation of that payment application, application 37. So you see application 37 on the slide, that refers to that payment application that was submitted by Clegg. And Clegg actually refers that dispute to adjudication. So it's back into that process. The kind of critical point here is that how protracted these adjudication proceedings were. So generally adjudication is supposed to be quite a rough justice. It's supposed to be quite a quick process. It's generally from cradle to grave about 28 days, can be extended, but it is supposed to be a quick process. However, in this case, the adjudicator made their decision for adjudication. The long and the short of it was the adjudicator's decision was in favour of Clegg. The defendant, of course, receives this decision and go, oh, but we can't understand the basis of your calculations. You've come up with a gross valuation figure, but we don't know how you got to that figure. On that basis, they actually requested that the adjudicator provide them additional workings, which the adjudicator did then do. So they gave them additional calculations. And what this did was it gave this new fair and reasonable rate that the adjudicator had used to come to that gross valuation. Clegg, being successful in the adjudication, then applies to the court for enforcement. And as you might imagine, Prestige then seeks to avoid enforcement on the basis that the adjudicator has breached natural justice. And they said, well, you've breached natural justice on two separate grounds. And the two grounds are these on the slide. So first of all, that the adjudicator failed to give the parties an opportunity to comment on this fair and reasonable rate. So that's the rate that the adjudicator has calculated in those circumstances. And secondly, that the adjudicator has failed to provide adequate reasons in their decision. And the basis for this was the defendant saying, well, we had to ask you for additional calculations after we received your decision. So how could you have provided us adequate reasons in the first instance? However, the decision of the TCC was that no, there's not been a breach of natural justice and you can't avoid enforcement on this basis. The court actually provided a really, really useful summary of the key cases and distilled the key principles from those cases, paragraphs 10 and 11 of that judgment. I'm not going to go through it here because in view of time, it's quite protracted, but it is really useful. So I would really recommend going through that if you are looking at breach of natural justice issues. But I'll point out a few key ones here that was important in this case. So the first one to note is that both parties' adjudication documents were quite broad in the scope that they afforded to the adjudicator in respect of the gross valuation. So both the claimant and the defendant both said, we think the gross valuation is X or Y or such other sums as the adjudicator shall see fit. And the court said, well, this gives them quite a broad bandwidth to make their decision. The second point to note was that the court was quite critical of the defendant's approach, and they said, well, they called this the overly granular approach in view of the aims and objectives of the act and the scheme. They said the adjudicator doesn't need to set out every element of their thinking. They don't need to set out their entire methodology and how they got to the decision. And this is in view of the act being this rough and ready justice and a quick system. It's not perfect justice. So they said, look, in light of what we're aiming to achieve here, the adjudicator didn't breach natural justice by failing to set out every element of their thinking. The other important thing to note in this case was that it was actually the defendant who'd asked for additional information after the decision. They said, well, you can't really fault an adjudicator for failing to give you adequate reasons when it was you, in fact, Mr. Defendant, who'd asked for the additional information and the adjudicator had complied with your request. And the last point to notice here is that the defendant hadn't actually suffered any substantial injustice. And this is really important to show when you're trying to establish a breach of natural justice. So the court had actually considered that this new fair and reasonable rate that the adjudicator had adopted, as shown in the documents provided after the decision to both parties, the defendant and the claimant, it actually benefited the defendant. in some circumstances, and on that basis, the defendant wasn't able to show that they'd suffered a substantial injustice, and therefore there was no breach of natural justice. So in terms of key takeaways from that case, natural justice is a really high bar. It is very difficult to show that you can avoid enforcement of a decision on the basis that an adjudicator has breached natural justice. And from a practical perspective, as the parties, when you're commencing the adjudication or responding to the other party, in fact, of their referral documents, be very careful in how broad you word those documents, because the breadth of that wording will affect the adjudicator's scope, which was a comment in this case. So in terms of a quick wrap up of those three cases, the first one is the importance of complying with the timing of the contractual payments and that contractual payment mechanism. So this harks back to that VMA and POL case. So from a very practical perspective, it is quite important to stay on top and keep abreast of, for example, if you're an employer, when you need to be issuing a pay less notice in response to a payment application, because it does have quite significant consequences in respect of this immediate payment obligation. So that case is quite useful, but really do have some sort of system that you can keep on top of to make sure you're complying with those timelines. The second key takeaway is what I've just been harking on to you about, is how difficult it is to prove a breach of natural justice to avoid enforcement of an adjudicator's decision or lack of jurisdiction. So that is quite a high bar, and you will need some very, very convincing evidence to convince a court of that. And the third point there is that it was not considered in any detail. It was just the nod to the DPA claims of having this very, very useful 30-year limitation period in case you were running into issues with limitation issues if in the context of contractual or tortious claims. So that's it for my segment. I'll now hand over to Patrick for any questions.
Okay, thank you very much to all of our speakers. We've got 10 to 15 minutes for questions. There's a couple on the procurement side, so I'll hand over to Sara or Naomi. First one is, how does, if a bid is unsuccessful, how do you get hold of documents from a contracting authority so you can assess the merits of a challenge?
Sure, I'm happy to answer that one. I think the first piece of advice is that you send a very strongly worded letter asking for it, because the unsuccessful bidder is at an inherent disadvantage because they don't have the documentation to necessarily support their position. But if you don't get it, then the next step you need to make is an application for specific disclosure. And there is a key principle in a test, the Roche test, which sees the court prepared to give unsuccessful bidders the documents largely in those circumstances. And there's actually been a lowering of the threshold for when you can get information, which is a case that we acted on last year. So we are definitely adept at getting those. And also what we're anticipating is under the new Procurement Act, you're going to see the ability to get those documents codified in a revised version of the TCC guide.
Excellent. Thanks, Naomi. There's a related question. If you're challenging a decision, how do you maintain that sort of commercial relationship?
Sure, thanks, Patrick. I'll take that one. I mean, we act on both sides of the fence. So we act for contracting authorities defending procurements and keeping the show on the road, and also for bidders challenging them. And so obviously we're aware of the sort of tips and approaches on both sides, and we can deploy that, that arsenal to our clients' best advantage. But that said, I think one of the most powerful ways of approaching these disputes that both sides have in common is actually just letting the facts speak for themselves in terms of playing the ball and not the footballer. Because in several of those examples that I mentioned, if you set those out, it's very powerful and very evident that, you know, something has gone badly wrong with this procurement and it needs to be remedied because it's unsafe, it's unfair, and it's not accountable. And that's, you know, some of the key language under the old PCR regulations, and that manifests itself in a different form of language under the new Procurement Act. But you know, sort of being firm but polite and courteous can achieve quite a lot in litigation, rather than some of the hyperbolic, emotional, subjective approaches that we see from some people involved in procurement challenges.
Yes, excellent. Thank you, Sarah. And then one more on the procurement side, sort of going right back to the beginning. How do we know whether it's the old PCR that applies, or whether it's the new Procurement Act?
Yeah, that's a good question. Well, it will be set out in the ITT if it's, you know, what it is. But if it's actually, if the thing to remember is that if it's a framework that was formed under the PCR, even if you have a call-off contract since the Procurement Act came into effect, it will still be under the PCR, which can potentially catch people out. But effectively, if it's a new procurement run and started after February this year, then it will be under the new Act.
Excellent, thank you both. There's a couple for you, Chris, on the new target cost contract. So obviously the JCT, as you mentioned, is putting itself in sort of direct competition with the NEC, having in a sort of equivalent and longer established form. Are there benefits to using the JCT's target cost contract over the NEC's option C?
Well, both have similarities in terms of the cost mechanism, because they both use target costs. They both use a pay and gain share mechanism, and both use open book accountancy. I guess for those who are used to JCT forms, then it may be easier, having got used to the procedures under a JCT, rather than NEC, which is more procedural and therefore requires more admin. So the JCT TCC in that aspect is not so burdensome. And I guess also NEC is a bit more collaborative in terms of early warning systems, particularly, and the good faith process, which are not included in a JCT contract. So there is, for those who are used to an NEC, that may be fine, and that's what they're used to. For those used to a JCT, then they can be comforted in that they have a JCT risk profile and procedures, but with the cost control mechanism in there.
Yes, yeah, absolutely. Thank you, Chris. On a sort of a related question, really, that if the target cost contract is ideal where cost certainty, excuse me, is an issue, but are there other benefits of using the target cost contract where, you know, beyond the certainty element?
Yeah, I think there's benefits in terms of, because it's a JCT, it's a D&B contract. So for those projects with a significant design responsibility, it can be used, but particularly also where the scope may evolve during delivery and their adjustments to the target costs are required. I think it's useful there. I think also there's some good scope within public sector projects, particularly those where there is more long-term programs, maybe like infrastructure or housing regen type programs, where there's repeat work. And I think the potential here for frameworks and alliancing can mean that the client can look at an evolving target cost as each project comes up. That's harking back to some of the old collaborative partnering models used a few years ago. But TCC also has a subcontract model as well. So there is the potential there for driving down to the supply chain, the same sort of incentivization that the employer is looking with the contractor. And also for public sector, of course, JCT identified that it's fully construction playbook compliance. So again, for the public sector, that's another tick in the box.
Yeah, absolutely. I mean, I think the fact that the JCT's introduced this option, as it were, has opened up the target cost opportunity to many more clients and contractors, because I know from my own experience quite a few clients and contractors wouldn't use the option C because it's an NEC contract, and we don't use NEC. It's an entire new language and an entire new set of processes, so it's not even considered. But if JCT is the form that you're familiar and comfortable with, it sort of opens up that mechanism, I think, to a lot more parties.
I think also, Patrick, I think just to highlight one of the challenges also is that there must be an appreciation that with the cost transparency and an audit model, there is a higher admin requirement here with the open book approach. And so if you're looking to use it, it's probably wise that a client or employer has the sort of appropriate resource that understands that additional burden, whether that's in-house or through external third parties.
Yeah, absolutely. Okay, thank you, Chris. A couple on the case law, Milana. So you mentioned smash and grab adjudications, which is always a great sort of fear in the industry, particularly around this time of year. How do we protect ourselves against smash and grab adjudications?
Yeah, it's a good question. I think the best thing that you can do, and this harks back to the VMA and POL case, the best thing that you can do practically is that practical point of making sure that you have some sort of system in place, whether it be, excuse me, calendar invites or something that will remind you of the timelines, because it is quite confusing in the Act. There are so many competing timelines, to make sure you're really across what date do you need a payless notice in, or what date would I need to put X in, and have some sort of system internally that will remind you of that, or whether it be to allocate some responsibility for doing it, just to make sure that you are complying with what you need to be doing by the certain deadline, because there are such severe consequences if you don't comply with it. I've never been able to get to the bottom of why they're called smash and grab. I've heard someone say that it's because it was the smash and grab of, out of a shop window, if you smash it and you grab it, you run away with the money, but I don't know the origin, so that's going to have to remain a mystery to me.
Mystery to me as well. And there's a question around the principle of natural justice. It's obviously quite a high bar, as you mentioned. How can you show that an adjudicator's breached natural justice? Yeah,
good question. It's very difficult. So that's what that Clegg case, that last case, made out. It's a very, very high bar. That case wasn't very prescriptive in what would demonstrate natural justice. They didn't say if you do X, this would be a breach. However, the two paragraphs, so I think it's paragraphs 10 and 11, are very, very useful in stepping out the key principles. And it's not prescriptive, but it would be something essentially like the adjudicator's gone off on a frolic of their own, and they're making crazy decisions that were never based in the original dispute. It'd be something along the lines in that nature, but the case law doesn't really give us a good example about what that is.
Yeah. Okay, thank you. And then a related question on the same principle. So if you can't show a breach of natural justice by the adjudicator, is that it? Is the court bound to enforce the decision if you challenge it?
Not necessarily. So the two most common grounds for avoiding enforcement is also a lack of jurisdiction. So that was the ground in POL and VMA. They said, well, you can't enforce the decision because the Adjudicator Act didn't actually have jurisdiction to make the decision in the first place. So that's the other potential ground for avoiding enforcement. And it's a fact-sensitive exercise, so it's a case-by-case basis. But that it's not all over for you if you can't prove a breach of natural justice. You also have that basis to try and avoid enforcement as well.
Excellent. Okay, thanks very much. Well, that brings us to a close for our winter webinar. We're a few minutes early, so an extra cup of tea before you're back at your desks. We'll send the recording after the session and a copy of the slides, and we'll also be in touch in due course for the next webinar in circa 3 months' time. And as always, if there's any particular topics you'd like to see, any particular legal updates, please let us know in advance, and we can make sure those are covered. So thank you very much to all of you for joining us, and we look forward to seeing you next time. Thanks very much.